A very happy good morning to all of you, dear students. The very first thing which I would like to bring to your notice is that received a mail from student bar association. They were having two requests which they made. The very first is that to reduce the lecture duration because they are asking for to reduce the lecture to 35 to something 40 minutes instead of making a long lecture. So this was the thing which I tried to bring to your notice because uh, these are the things which are going on as a part of academic committee that was shared to me also, and I came to know about this particular thing. Apart from that, there is another thing that when we talk about sharing of the things, you should know that what's going on. So accordingly, we can work over it. Okay, now coming back to the reopening of the partition. This was the topic which we have seen and we have discussed. You are able to remember, you able to get it. Okay, wait a minute. No problem. Are you able to get it? The reopening of partition, or should I try once again? Because it is difficult from my end to know whether you are able to see the slides or not. I'm in a chaotic state. What to do? Wait a moment. Then I will try to see whether you are able to see or not. Okay. Now I hope you are able to see because it has been shared. Okay. So, dear students, today we have to start the concept of reopening of partition. So, I started, I have quoted a text of Manu. This text has been discussed in the writings of Manu, and according to him, he says that once is the partition of inheritance made, once is a damsel given in marriage, something which is given, and once a man say, I give, these three are by good man done once and they are done irrevocably. It means that you are not in a position to destroy it, to take it back. So these are the lines which we used to have, sort of the guidance we can say, which were there and which have been propounded by Manu. So on the basis of this particular text, a view had been propounded that if a partition has been made once, it is final and it is irrevocable, and therefore it cannot be reopened. Another text of Manu runs that after all the texts and assets have been distributed according to this rule, any property is afterward discovered, it must be divided equally. Okay, it has also been discussed in Manu. Apart from Manu, the text does not explicitly, it is not something which is very clear regarding the reopening of partition. If you go to the text, you will find that there is a sort of ambiguity which is present in the text, and it is talking about the distribution of the discovered property. Okay, it is not very clear on reopening of the partition. It is talking about something that we can say it's talking about the distribution of property. Okay, and Eugene Velka also when we discuss his text, although his text I haven't mentioned, when we go through his text, he's more clear. He declares that the central rule is that a co-hire should be given or should again divide on equal terms wealth which being concealed by one co-hire from another is discovered after partition. So he's having a view that the settled truth is that the co-hires, the co-partners are there, the other hires who are there, again divide on equal terms wealth being concealed by one co-hire from another and is discovered after partition. So there are different views. We can say that there is no such thing. Also, when we see the Smriti Chandrika and the Daya Bhaga, they are also having a view which says that uh, Satyanya also ordained that the property of which an unequal distribution has been made, contrary to law, a property which has been distributed unequally, the partition which has not followed the principles of equity, uh, such property can be recovered after being seized or lost, and then it should be redistributed. So these are the texts which are there, which are in the scriptures, and therefore, what we can say that different opinions have been formed. And in the case of Moro versus Ganesh and Ratnam versus Kuppuswamy, the case which we are able to see on your screen, the case which is visible, it has been held that the courts have taken the view that though a partition once it is effected is final, okay, and yet it can be reopened in the case of fraud, mistake, or subsequent recovery of property. The court is having a view that these particular in these particular instances where the property has been made or where there is a fraud or a mistake or something similar to it, misrepresentation, whatever, then it can be reopened. And this particular principle has been discussed in these two cases. Mauro versus Ganesh is an old case of 1873, I suppose, okay. And Ratnam versus Kuppuswamy is a post-independence case which happened in the year 1976. So, dear students, there are two different, what we can call it, we can say that there are different opinions regarding the same. Okay, okay. So we can say that following this particular thing, the matter can be further discussed. Okay, that there are two angles which give rise when the partition once is final and yet it has to be reopened in the case of fraud or mistake, or we can say subsequent recovery of property. So there can be two angles which are there. The very first is readjustment of property. The first one you can call it A, okay, and the other one which we can call B is reopening of partition. So by this we are able to understand that it gives rise to two situations. Readjustment of the same thing and the reopening of the property. Okay. So when we say that readjustment of the assets, it is something which is again very clear from the scriptures. The scriptures themselves are having a notation that in the text of Manu also talks of one of the case of readjustment of the properties are discovered after the distribution of assets has taken place. Is discussed. Okay. And when we talk about there may be other cases of this nature. For instance, some properties may be left out from partition by mistake. So if in a situation where the properties have been left out, we can say out of mistakes or we can say oversight, or some lost properties may have been recovered. In certain circumstances, what we can call it that this particular readjustment of property can be taken place. Okay, there are different instances which we can say that the properties have who has been distributed has been postponed because there was the possession in the third person. The possession was not there, therefore the property hasn't been distributed, and therefore we can say that in such particular case the property has been we can say was mortgaged. And in certain situation where the property is mortgaged, again you are not having the possession of the property until the amount of the until what we can call the debt is cleared. Then only the one is having the right over that particular property. So these are the instances in which we can say that the process of readjustment may apply in case of inequities which may be adjusted with which we can say without distribution of the entire division of properties. Okay, and also in the case of uh, Krishna versus Janki, in this particular case, further it was discussed that the general rule is that when adjustments can be made, a partition may not be reopened. The Krishna versus Jani case was discussed in the year 1951, and Dayabaga is talking about the same effect, which has already been divided, is not been divided again. And also the Mitaksha school of law is having the same, what we can call the same premises. They are also having the same view therefore, in the case of Krishna versus Janki, this particular case, it was held that the general rule is that when the readjustment can be made, partition need not be reopened. Okay, so we can say that there are certain slight inequities, and those inequities can be adjusted. Those inequities can be adjusted without disturbing the entire division of property. Then we should go for the readjustment of the properties and not for a reopening of a partition. So when we are talking about reopening of the partition should be the last remedy, the last resort if the parties are in a position to work the what we can call readjustment. And when the readjustment is not possible, and there are certain circumstances, there are situations in which we can say that readjustment cannot be made because the partition is a requirement. And when the elements of reopening of the partition are fulfilled, for example, fraud, misrepresentation, undue influence, and we will be discussing in length what are the grounds of reopening of partition. So under such circumstances or under such situation, what we have to do, we only have to, what you can say, we only have to reopen it. Are you able to get it? So this is what by the term of reopening of the partition. Okay. So once again, coming back to the slide, I'm very not sure whether you are able to see it or not because the monos are not coming here of the WebEx meetings. I hope that I have not to, I haven't, again, I have to go for the recording. Okay. So this is the case of readjustment of the properties. Okay. The second situation is the reopening of the partition. So as we have seen, what has been discussed in the case of Moro versus Ganesh or Ratnam versus Kuppuswamy, the courts have taken the view that though a partition one is affected, it is final. Yet the court says that it can be reopened in the case of a fraud, mistake, or subsequent recovery of property. So when they are talking about subsequent recovery of property or fraud or mistake, then it is the duty of the court or the people who are responsible for reopening of the partition to check it. If the properties can be readjusted, then they should opt for readjustment of the property. And if they are not able to do so, because the elements of reopening what we can call it, the readjustment of the property is not possible, and the entire partition has to be reopened. We all know that generally a partition can be reopened if it has been obtained by fraud, coercion, misrepresentation, or undue influence, all those conditions of voidable contracts. Yeah, those particular situations or conditions then open the gate of what we can call a reopening of partition. Is it clear to you? Moving to the next slide. So it was held that in the same case of Ratna versus Kuppuswamy case, as we have discussed in the last slide, also the same case, that the partition can be reopened if it has been obtained by fraud, coercion, misrepresentation, or undue influence. Okay. So when we talk about the term fraud, this particular thing was discussed in the case of Badinath versus Lokanath. Okay, and it was held that when the whole scheme of distribution of property is fraudulent, when the whole scheme of distribution of the property is fraudulent, it would amount to fraud. You all know what is fraud. Okay, mischief and what we can say, the crucial facts have not been discussed and the intention was not good, all those things. So, and in the third case, the case is front of your, the case which is there on the screen. The name of the case is Devarata versus Janendra. In this particular case, it was held that the court will order to set aside whatever distribution has been made. So it will be ordered to be set aside unless the persons injured has and we can say acquiescence in it with full knowledge of all material facts, which means that nothing has been hidden or deceived or things have not been manipulated. The things will be set aside. If the people are knowing it, then it is okay because it's not in their knowledge. If the people are able to tell the court that things were not in front of us and there was a deception which occurred, some sort of manipulation which took place, then again it will amount to fraud. Okay. So these are the instances which we are discussing. Again, we can discuss a case of you can say Garu Swami, so that is Garu, Garu Swami case versus Jayashman, Garu Swami versus Jayashman. In this particular case also, it was held that the worthless assets, those assets which are not, which we can say are having any value, have been given to some co-partners. What has been done? The assets which has been given to the co-partners are, we can say, are having no value at all. Okay, and on the other hand, we can say valuable assets have been given to other co-partners. There is some sort of, we can say, ill intention which we are able to see. It is apparent. Worthless assets have been given to some co-partners as valuable assets, and or when a property which does not belong to the family has been allotted to some co-partners. So under such case also it will amount to fraudulent, and when it is fraudulent we can say that it will be unjust and unfair, and therefore we can say that under such circumstances also it will affect the interest, or it will be unfair or detrimental to the interest of minors, and therefore the partition needs to be reopened. So you can do one thing, you can read these two cases together because they are, we can what we can call, they are adjacent to each other in terms of we can say fraud, in terms of a partition which has been made with the fraud intention. So what happened in the cases where we can say useless or worthless property have been given to some co-partners, the valuable assets, or when a property which does not belong to the family has been allotted to some co-partners, then it is unjust and unfair or detrimental to the interest of minor partition, and the partition will be reopened. Okay, so this is the case of fraud. Now, a partition can be reopened, as I am telling you, in these particular circumstances which are there, and we are discussing the others also. The second is the son in the womb. This we have discussed in detail. So I'm taking only one case of Amman versus Himacharya. And what happened that we have seen also earlier that if at the time of partition a son is in the womb and no share is reserved for him, so he can get the partition reopened. He's having that particular thing. It is in the old case before the Hindu Succession Act came into being. Time and again, I'm telling you, to not get confused by the after the codification of Hindu law, how the whole scenario has changed and what was the practice earlier. So we are discussing we can say classical law that whenever there is a son in the womb, a partition can be reopened if the son hasn't been no share has been reserved for him, and then he can ask or he can get the partition reopened. Okay. So another instance of what we can call it the instance of an adopted son. As we all know that adopted son is also having certain rights, and we have seen that when son is adopted, the general psychology or mentality of common man is that he is deemed that he's not treated as par, he's not treated equal. There is some sort of feeling that he is outside the family, and that was the reason that he was deprived or he was not neglected in terms of succession or partition. So, adopted son, a son adopted to a deceased co-partner by his widow after partition is entitled to reopen the partition. If he, what we can say, occupies the law, if he occupies in law the same position as a posthumous son, okay, if he is able to prove in the court of law that he is equal to the posthumous son, the son who was there, in such a case, he should be awarded his share in the property. And this was discussed in the case of Krishna versus Gopala case that during the existing at the date of his adopted father's death, he is also entitled to a share in the acquisition, the family property, which remained with the sole, we can say, surviving co-partners. So adopted son, if he has been denied, again the partition can be reopened. Okay. So dear students, this is what we are seeing. Let me check what is the position. Okay, okay. I hope that things are you're able to see the things. Okay. So when we talk about the disqualified co-partners, a disqualified co-partner is one, and we all know that who were the disqualified co-partners before the Indian Succession Act came into existence. Okay. Generally, this particular concept has been discussed in the case of Bhagwani disqualified co-partners, Krishnan versus Swami case. In this case, it was held that a disqualified co-partner who recovers from his disqualification after the partition can get the partition reopened. Okay, if he was an afterborn son, so he's also having the power to ask for the what we can call it to get the partition opened. Okay. Then we are having absentee co-partners. So at the time of partition, it was discussed in the case of Umakant versus Rithiban that if at time of the partition, a co-partner is absent and no share is allotted to him, he can get the partition reopened. In case of minor co-partners, we have seen the case of, which we can call it the case of Vishnu Deo versus Thiogani, and second case of Ratna versus Kuppuswamy case. In these cases, it was held that when a partition is effected during the minority of a co-partner, he can get the partition reopened if he can show that the partition was unfair, it was unjust, or it was a prejudicial. Okay. So these are the instances which we can say in which the partition may get reopened. Apart from that, there are a few more cases. The case of what you can call Venkata versus Subramanya versus Ishwara case, the very first case on your screen. You're able to see it. The very first case, the Madras High Court held that when in a partition one member gets an excess share, and out of the income of the excess share, he acquires a fresh property. Okay, he does not hold the fresh property for the benefit of other sharers, and the partition is subsequently reopened on the ground of unequal partition. But however, he will be liable to account for the co-ownership fund used by him. Right? It is another instance where the money or what you can call the excess share has been misused, and what happened? The co-pastor has acquired a property, a fresh property. Although he is not holding the fresh property for the benefit of the other sharers, and what he is doing, he is not holding it for the benefit of other sharers. Say he's purchased a shop, and now he's getting the rent, and he's using the rent. He's not distributing it equally. In such circumstances, what is the case? Co-partners are having the right to ask for a reopening of the partition. Okay. So the last case which is there, Hariharan versus Patrick. In this particular case, it was held that a family arrangement, the enforcement of which becomes impracticable, that can be reopened. So, and in a situation where the arrangement, the partition arrangement, or the enforcement of which is impracticable, it is not possible to do the partition. You have divided the house, such say. Suppose we used to have, if you have gone to the old cities of your own town, wherever you are staying, there are certain circumstances what happen. Say there is a house, and in that particular house, the first, what you can say, the first uh, room or the first place of that particular house is a shop, and that shop has been given to a particular co-partner after partition, and there was another story above the shop, and that story has been given to some other co-partners, and that story, that floor, above floor, was having a separate, we can say, staircase, and the other third co-partner has been giving certain property which is inside. And if you want to go to that particular property, you have to terrace past the shop. You have to pass by the shop. And this particular co-partner who is owning this shop has, what we can say, is not allowing, or rather he has constructed or he has closed that entrance by which the third co-partner will go and come out. So this particular arrangement, we can say, is impracticable. How that particular third co-partner will enter to his place if all the obstructions have been created? It is something which is not practicable. So in this particular situation, we can say that these are the instances in which it is impracticable, and hence the partition may get reopened. So today, students, we have seen the concept of reopening of partition, and I hope that everything is clear to you. And in the next class, which is tomorrow, we shall start the last topic of partition, which is reunion. And I hope that we would be able to complete it in the next class. Maybe we can take some time, but reunion is more what we can say lengthy as compared to reopening. So for today, I hope that this is enough for today. And tomorrow, we shall start the concept of a reunion of partition. Because I need to have a fresh class also. As I told you, there is a demand, the request from the students not to lengthen or rather to shorten the lecture timings. So it is not possible for me to complete in 5 minutes time the whole concept of reunion. I won't be able to justify it. Okay, it will be better for us to have that particular whole topic in a fresh class and then to complete it. So I hope that everything is great at your end and you people are doing your best of your, you can say, of your health. You are having good health and everything is fine with your family members also. So this is for today and I hope you were able to get what I have said. Thank you for your patient listening. Thank you.